So thank you all for coming to our Human Rights in Practice event, Torture Flights, North Carolina's Role in Rendition and Torture, organized by the Duke Law International Human Rights Clinic and the Center for International and Comparative Law. Our event today is also part of the Duke at Home in the World series, organized by the Office of Global Affairs. Duke at Home in the World is a month-long series of events highlighting the work of schools, institutes, departments, and student organizations throughout Duke that are engaged with communities all over the world. We're also very grateful to our co-sponsors, as always, the Duke Human Rights Center at the Franklin Humanities Institute, whose faculty co-chair, Professor Robin Kirk, is here with us today, the Duke Human Rights Center at the Keenan Institute for Ethics, and two student groups, the Human Rights Law Society and the International Law Society. Before turning the floor to our speakers, I'll provide a very short introduction to these torture flights and the North Carolina Commission of Inquiry on Torture, or NCCIT. On November 30th and December 1st of last year, 2017, the NCCIT, consisting of 10 commissioners, including Professor Coleman and Professor Kirk, heard testimony from victims, former interrogators, religious leaders, and legal experts, including Professor Jayne Huckerby, on the role that North Carolina played in the CIA's rendition, detention, and interrogation program, known as the RDI program, after 9/11. The commission is an independent, citizen-led inquiry examining the role that North Carolina played in the CIA's program. The nexus between North Carolina and the CIA's RDI program is that a company called Aero Contractors Limited, based here in North Carolina, operated aircraft that were used in these renditions. Quoting from the executive summary of the report, quote, between September 2001 and March 2004, Aero-operated aircraft were used in more than 80% of identified RDI renditions. Over the full length of the program, Aero transported 34 of the known 119 CIA prisoners, plus at least 15 of those sent by the CIA to foreign custody, on 69 identified rendition circuits. These flights, using North Carolina's public infrastructure and flown by its citizens, implicate North Carolina directly in abduction, forced disappearance, and torture. End of quote. This figure of 34 represents almost 1/3 of the at least 119 individuals known to have been in CIA custody. Local and state officials are also implicated because they provided 2 of North Carolina's public airports for rendition flights and refused to investigate any allegations of their role. In September of this year, the North Carolina Commission of Inquiry on Torture, the NCCIT, released its 83-page final report on North Carolina's role. The report was launched at an event at the State Capitol building in Raleigh, where Catherine Reed and several commissioners, including both Professor Kirk and Professor Coleman, spoke. The report itself draws on information gained during the public hearings, as well as other data and results of investigations. In addition to the extensive findings in the report, the NCCIT report also makes a number of important recommendations to federal and state officials, as well as to North Carolina citizens. I'm very happy to turn now to our speakers, each of whom has been instrumental not only in the work of NCCIT itself, but more broadly and more deeply in the work of uncovering and seeking accountability for North Carolina's role in the US RDI program. Thank you all for being here. I'll introduce the speakers in the order in which they will speak. And before introducing our speakers, I'm sorry to announce that unfortunately Mr. Mohamedou Ould Slahi, a former Guantánamo Bay detainee for 14 years, who was rendered by Aero Contractors, and who spoke of his experience during the NCCIT hearings as an expert witness, was unable to join us today because of some technical issues. As mentioned in the announcement for this event, Mr. Slahi is the author of Guantánamo Diary, which is an account of his experiences. And a restored edition of this book was recently released, which also includes previously redacted sections. So I would very much encourage you to buy the book if you're interested in learning more about his experience. And his experience is also on his testimony is on the NCCIT website under the public hearings section, where you can also hear him, the testimony that he gave to the commission last year. So before introducing our speakers, I also wanted to acknowledge a few students who are here who have been very instrumental in the work of the NCCIT as part of the International Human Rights Clinic. So we have Sophia Durand, Lauren Hughes, and I'll mention the others who may or may not be here: Andrew Smith, Matthew Kramer, and Gabrielle Skillings. So turning to our speakers in the order in which they will speak, we have Professor Jayne Huckerby, Director of the International Human Rights Clinic and an expert witness at the NCCIT hearings. Professor Jim Coleman, co-director of the Wrongful Convictions Clinic here at the law school and a commissioner on the NCCIT. Professor Robin Kirk, faculty co-chair of the Duke Human Rights Center at the Franklin Humanities Institute, who served as co-commissioner of the NCCIT. Catherine Reed, the executive director of the North Carolina Commission of Inquiry on Torture. And Dr. Christina Cowger, who has led the efforts of North Carolina Stop Torture Now, a grassroots coalition with the goal of stopping torture that's been actively working since 2005 to expose and end North Carolina's role in the U.S. torture program. I'll ask each of the panelists a couple of questions, and then we'll open it up to your questions and comments, which we very much look forward to. So starting with Professor Huckerby, please talk us through the legal findings contained in the final report of the NCCIT, particularly the finding that international human rights obligations do apply to the state of North Carolina, and that the U.S. government can be held liable for the acts of private actors, namely aero contractors.
Great, thank you for that very thorough and kind introduction. What I'd like to do before going through the international human rights law findings in the report is just briefly summarize the types of activities that comprised the CIA rendition, detention, interrogation program, just to have a sense of what we're applying the international and domestic law framework to. And so when we think about analysing these activities through international law, we're particularly concerned about the initial apprehension of individuals in the program, their preparation for rendition, which involved incredibly invasive procedures amounting to torture and cruel and human degrading treatment or punishment on the tarmac of foreign airports around the world. After having gone through a rendition procedure, individuals were then transferred on flights to either CIA black sites or to foreign governments, or often to both. You could also be in a situation where you would be circulated amongst multiple CIA black sites. If you were in a CIA black site and part of the CIA interrogation program, you would be subject to what have come to be known euphemistically as EITs, enhanced interrogation techniques, including, for example, waterboarding, forced standing, sleep deprivation, and other interrogation techniques. If you're sent to a foreign government for interrogation, you're also subject to coercive interrogation techniques. On the closure of the CIA program, the fate and whereabouts of individuals that were in the CIA program, and also particularly those sent to foreign governments, remains almost entirely unknown. There were a number of individuals who were identified in a key report of the US Senate, the redacted summary of which was released in 2014, as having been wrongfully held in the CIA program. But beyond that, there is a huge information and accountability gap around the number of individuals that were subject to the CIA program and held in CIA black sites, but also more broadly put through a US supported rendition program. Okay, that was the quickest summary possible of what was entailed, and definitely does not do any remotely come close to doing justice to the nature and the travesty of the violations involved. But let me just talk through equally briefly how we approach this from an international law perspective, and to put the context of the findings in the NCCIT report in play here. So when we think and talk about US obligations under international law, we're talking about international law obligations that comprise a series of international human rights law obligations, humanitarian law, criminal law, and refugee law. Focusing particularly on the international human rights law piece, there are 5 major contributions of the NCCIT report in this respect. The first of which is to show how, as was mentioned, international human rights law and treaties that the US government has ratified at the federal level also bind state and local authorities, right? As under international law, when a federal entity enters into a binding legal arrangement, such as a human rights treaty, that binds all entities of the state, of the government of the sort of government more broadly, and requires each level of government to fulfill those human rights treaties, according to their competencies. The second major finding with regard to international human rights law is a strong reminder to local, state, and federal officials that human rights law applies to US government actions in territory, right, so within the United States, but also what we call extraterritorially, right, outside the United States. And that was particularly important because, as was evident from the brief synopsis of the factual components of this program, much of these activities happened overseas. Foreign tarmacs of airports, foreign government detention facilities. All the CIA black sites were hosted either at Gitmo or in foreign countries, right? So we're talking about quite a deliberate legal maneuver on behalf of the US government to put these programs outside the United States, and an argument that went with it during this time period that international human rights law didn't follow those activities, that it stopped at the border. And the NCCIT report is a really important corrective to that, as a reminder that human rights law applies in territory, out of territory, and it continues to apply during the war on terror. Again, an argument from the USG during that time period that has been since revised is that international humanitarian law was the only relevant governing law. That during the war on terror, international humanitarian law displaced the application of human rights law. The third key finding of the NCCIT report with regard to international human rights law is that these obligations clearly regulate what governments can do, like governmental officials, but they also extend to require governmental officials to regulate the actions of private companies, right? Under international human rights law, a government cannot outsource bad activities to private actors as a way of abdicating responsibility. So in this case, for example, utilising private aircraft companies to fly rendition flights, right, which was so key to the program, is an example of a government, seeking to outsource an activity that they know would actually be illegal if they did themselves directly under international human rights law. Fourthly, and this is particularly, I think, one of the major contributions of the report, is to really go through and in quite meticulous detail look at how these different activities actually violated a series of international human rights norms. And to name those norms, that's a prohibition on torture and cruel, inhuman, degrading treatment or punishment, the prohibition on disappearances, right? So when you talk about a CIA black site, under international human rights law, the word that we put on that is disappearance. That's a disappearance. There's also reflections on the ways in which these programs and activities violated the right to life, the right to family, the right to privacy, and the right to non-refoulement, which under international human rights law simply means that not only can you not be tortured, you also can't be transferred to torture, right? It's something, again, that you can't put these activities outsourced to foreign governments to do your bidding. What was particularly important in international human rights law analysis is much of our focus in the human rights community on the CIA program has been on the detention and interrogation piece. Remember, it's sort of the black site or the enhanced interrogation piece. And there has been a slight overlooking of actually how incredibly rights violative the rendition piece was. So the apprehension, the preparation for transfer, the actual experience on the aircraft that these men attest to, that itself constitutes a form of torture prohibited by international human rights law. Finally, what the report makes very clear, and where the report is located in the landscape of accountability, is that the US government not only violated rights of individuals throughout the duration of the program, but by failing to investigate what happened, by failing to provide a remedy, this is an ongoing violation of the USG. And until there has been an accounting for those victims, the US government will continue to be in breach of its international human rights law obligations.
Thank you. So Professor Coleman, we're going to turn to you now. But the first question is that you spoke at the NCCIT report launch about the connection between the experiences of those individuals who are rendered and tortured under the CIA's program and the experiences of people of color in this country and the systematic and structural discrimination, racism that's impacted their experiences, including with respect to access to justice. Can you elaborate on this point that you made?
Yeah, well, this international human rights is not an area in which I have worked for the most part. So my interest in the work of the Commission, obviously I was interested in what the United States have been doing under this program. But more broadly than that, I was interested in it because of what it said about respect and the rule of law in this country. When I was in law school, the big public policy discussion that law students and lawyers were having involved Watergate and, systematic violation of the law by the president and his administration, and the role that lawyers played in covering up and designing the conduct. So my view about these kinds of systematic violations of the law is that it's comparable to what the United States has done historically. First as a slave nation, and then subsequent to that, after slavery was abolished, there were systematic efforts to deny American citizens their rights, and the violations were ignored. In the 60s, one of the things that got the federal government to take action in the South was the videos of the police using dogs and fire hoses against innocent black citizens who were protesting the way they were being treated by the government. So I think that, we do not often think about human rights in terms of what happens in the United States. And I think that is a mistake. And I think those of us who care about civil rights ought to be concerned about human rights, and we ought to see what happens in the United States in terms of human rights as well. This is all basically the same conduct by governments. Generally, we have in the past thought about human rights violations as something that occurs outside of the United States, involving governments other than our own. But I think this program is an example of a systematic effort by the United States that violated international law and domestic law, in which lawyers played an important role in making it possible. So, I was on the commission because I was concerned about those broader issues, and I wanted to do what I could to make the connection between violations that we normally dismiss sometimes as things that don't affect us, and make it clear that these types of violations not only happen in this country, but also our government is involved in them.
Thank you. Professor Kirk, the NCCIT was made up of commissioners from a diverse range of professional disciplines, ranging from legal experts to religious scholars, to medical professionals, and a former colonel. As co-chair of the commission, how did you address any challenges that might have arisen as a result of this diversity, and the different issues that different commissioners might have wanted to focus on, especially in finalizing the recommendations?
Thanks for the question, and thanks again to the organizers for organizing this, and for everyone for coming. I should clarify that I was co-chair for part of the time. My colleague Jen Daskell was co-chair for part of the time and had to withdraw for personal reasons. But I think it was a very well-chosen group of people. As Aya notes, we had people from a variety of different backgrounds and engagements with this issue, but everyone, I think, came to the table with a very heartfelt sense that they wanted to listen, to look at the documentary evidence that we collected, and then also to have a discussion, an honest discussion among commissioners. No one came with a completely closed mind one way or the other. So I think that it was important, and for me, as someone who studied truth commissions and studied these processes, both in the United States and elsewhere, I think it was really important to have that conversation And the educational aspect of it, when we had the 2 days of hearings, was absolutely fundamental, because part of the job of commissions like this, or any sort of truth-finding exercise, is to also be, as in my view, educating the public. And I think that was a big part of all of our commitment, was that we wanted to be engaged on this as commissioners, bringing each of our expertise to the table, but we also wanted to very much engage with the larger community of people who cared about this, but also people who maybe didn't know about this. And these included, and I think Jim's point was really well taken, about how civil rights or human rights is seen in the United States. And I think the commission, and particularly Catherine and Christina, really brought a sense of connecting this issue to other issues in the United States, including mass incarceration, including police misconduct and torture. These are not separate issues. And for the committee, I think it was really important that we connect the dots, and that we see this certainly as a program in space and time, but also that drew on a lot of behaviors and a lot of problems that we have that we face in the United States every day. I'll just mention one case of, this is not part of the report, but it's something that you'll probably remember from the very early part of the torture program, when there was, when it was revealed that there was massive torture in one of the prisons in Iraq, in Abu Ghraib, and some of the low-level officers, at least one in particular that was involved with that torture, had been a prison guard in the United States. So it's not, these things are not unassociated in some ways. I'm personally from the city of Chicago, and Chicago has had one of the worst police torture cases in the United States. These are not unrelated. So when we shine a light on programs like this one, we're also shining a light on the issue in general of torture, and how whether it be through law enforcement or whether it be through our international relations, how we are treating people and to what degree we're respecting and enforcing the rule of law. So this is, I think, an opportunity to look at a very specific program, but it also raises questions that I think all of us on the committee were concerned about, in terms of the relationships between what happens in the United States and how that's then exported to other countries. There were certainly disagreements, I think, on the committee about different weight to give things. People were certainly concerned about whether we were interpreting the law correctly, concerned about, I think, the well-being of individuals who'd suffered torture, and that's why it was we had testimony from Mohamedou Ould Slahi for the commission hearings, and I think that was both really important and also really difficult, because we knew that we were asking him to relive some of the worst moments of his life. And I think we all, as a committee, really approached that with a great deal of humility and a great deal of gratitude. And I think that's one of the conclusions of our report also, is that we really still owe the people who suffered because of this program a lot. And we felt, as commission members, very personally implicated in this. And we really, I think, in the end, really pulled together to try to do a good job.
Catherine, can you share with us some of the efforts that you've been leading since the release of the report to disseminate the findings and push for implementation of the recommendations, and specifically some of the entities that you've been targeting, and if there are specific recommendations that you've been placing particular emphasis on?
Sure, thanks. Hi, everybody. Thanks for having us here at Duke. So yeah, even though the commission is formally kind of come to an end and the work of Jim and Robin has, the most important work of it is really starting now, because it's really how we get this out into the right people's hands. So we are going from all the way from the local level, the very local level at Johnston County, where the airport is based, all the way to policymakers in Washington. So we have requested meetings or had meetings with the Johnston County commissioners, with other local officials there, with the airport director, with the local district attorney, with the sheriff. We have met with representatives of the Attorney General, Josh Stein, and we are pursuing a meeting with the governor's staff as well. We are this week heading to Washington to release the reported events there and to meet with policymakers in DC. We'll be having events in the House and the Senate in December. And we've spoken as well to members of Congress, North Carolina members. We've talked both to Representative Jones, and we'll speak to Price this week. So we're really trying to get it out into kind of all levels. We're also doing events like this, trying to educate all levels, from students to other human rights NGOs, to people of faith, to veterans across the state, and working with colleagues on national level, human rights organizations as well. We're working with Aya and Jayne about making sure the report also gets to the international level, to the International Criminal Court, which is actually, as you may know, investigating US war crimes in Afghanistan. Also to UN officials, the rapporteur on torture, and other relevant rapporteurs. And we also found out this week, we sent it to the UK Parliament has a group on extraordinary rendition, and they sent us a note back saying that it had already been quoted in a submission that the British Parliament had made. So, this is the important work. It's to get it out there, as I talked about this issue of education. And, many of you may have been young when this was happening. Like, we need to make sure that this isn't forgotten in history. As we've talked about, the victims are still suffering. And so this is some of the most important work now is getting this out. Should I talk also about what we've learned over the commission?
Come back to you for the second.
Oh, okay, great.
And Christina, during the official launch of the NCCIT report at the state capitol in Raleigh in September, there was a bell tower art installation on display. Can you describe the installation and through the purpose that it served at the launch?
Sure, thank you. The bell tower is of course, the large symbol of North Carolina State University, and it commemorates the veterans from North Carolina, specifically from NC State, who died in World War I. And their names are actually inscribed on the inside of the tower. So a group of peace activists have made a replica of the bell tower, and they're using it. In fact, they've been using it this past weekend in the centenary events around World War I's ending, and also to have people make inscriptions on little plaques made of soda cans beaten into rectangles, inscriptions about what war means to them. So it's an opportunity for people to participate in talking about war and the costs of war. In the case of torture, which of course the torture program arose as a part of the so-called global war on terror that George W. Bush's administration launched, the replica bell tower was erected there at the state capitol with plaques bearing the names of the 49 human beings who, as Aya mentioned, were transported by aero contractors. So planes actually took off from North Carolina, from Kinston or Smithfield, and picked those people up and took them to places where they were tortured, and took them to multiple places sometimes, and then came back and landed in North Carolina. The pilots all live near Smithfield and in Johnston County. Several dozen pilots who are our fellow citizens were involved in that effort over a period of a number of years, transporting people to be tortured. So the names of the 49 human beings were inscribed, each one on a little metal plaque hanging from the bell tower. And that symbolism then with the ringing, there's actually a bell inside the little replica tower that can be rung, and so that was rung 11 times during the ceremonies around the launch of our report.
So we're going to go through one more round of questions, and then we'll open it up. So back to Professor Huckerby. Can you discuss how the NCCIT fits in with the global landscape for accountability on post-9/11 activities?
Okay, so outside the United States, there have been a number of efforts to really gain accountability for actions that comprise this post-9/11 program. So for example, there have been 2 high-profile inquiries in Europe, one in the Council of Europe, one in the European Parliament. There have been 5 cases before the European Court of Human Rights that actually concern the North Carolina based aircraft N313P and N379P that were operated by aero contractors. There have been 3 cases submitted to the Inter-American and African regional court systems, and there have also been a series of foreign court cases, again, concerning activities that originated in North Carolina. So outside the United States, the picture of accountability, while far from complete, is a bit more robust than what we've faced domestically. So within the United States, there has been no case that has actually proceeded regarding victims of the CIA detention and torture interrogation program, including, for example, cases that were brought against government officials, but also against private aircraft companies, including Jeppesen Data Planning, as an example. And the reason they haven't proceeded is on the grounds of state secrets, primarily. So the courts have not been helpful on accountability in the United States, nor have the governmental inquiries been particularly helpful on this front either. The major inquiry, as I mentioned very briefly, has been the Senate inquiry into CIA torture and interrogation. But that inquiry, again, the redacted summary of which has been released, the full report and non-redacted version has not been released. That summary was, that report was inherently circumscribed because it doesn't focus, for example, on rendition to foreign governments, only if you end up in a CIA black site is a part of the report. It doesn't focus on private companies, except for one brief reference to the individuals who devised the interrogation program, and nor does it focus on state or local officials, right? So the picture is inherently incomplete. So where the commission fits in, in that sort of very incomplete picture, is really showing that in cases where official inquiries, when courts are closed within the United States to these issues, that non-official or citizen-led inquiries become really the most effective means of taking on the complex interplay of local, state, federal and international violations that are very much represented by the CIA detention interrogation program. I want to really echo as well Professor Kirk's point about the way in which this particular model of accountability, which just looks like what we call truth commissions in other country contexts, right, that are very much part of the landscape of transitional justice as we understand that as lawyers. A real key contribution here was to actually have the testimony of victims and family members be presented to the American public. Now, that hasn't happened before in this particular format. Again, because the cases have not proceeded, although individuals, including one former client of mine who was held in the CIA program, although individuals are able to submit quite comprehensive declarations as part of the court cases, when they don't proceed, the ability of someone to actually share their experience is cut off. And so there's something particularly significant about non-official inquiries of this nature that can connect victims to the American public, that can enable their stories to be told in ways that are not filtered by the strictures of court proceedings. And I think just to sort of note on that this type of proceeding is no substitute for legal accountability, and one core recommendation of the report is indeed investigation, prosecution of key actors involved, from private actors through the government officials and so forth. But it does, there is a precedent for these types of non-official inquiries to really provide the impetus for more official accountability, including by laying out the fact pieces that are not known to the American public. And again, indicating that there is a push from the ground, right, from the grassroots, to hold actors to account, even when the government itself is being intractable in that space.
Professor Coleman, can you please discuss the NCCIT's major recommendations, particularly with respect to investigation and prosecution under federal and North Carolina state law?
Okay, so when the conduct that was being carried out by North Carolina-based parties was brought to the attention of officials in North Carolina, they basically either avoided meeting with the citizens to discuss it, or they said that there was nothing they could do, that this was not a matter for North Carolina. So one of the things that we did on the commission was to look at both federal law and state law to determine to what extent North Carolina officials were able to take action in connection with what was going on, in connection with the systematic violation of both international law and national law relating to the kidnapping and torturing that was being carried out. What we concluded was that both the federal government and state governments have the authority, and in the case of the federal government, had the obligation to investigate these activities. Now, obviously, because they were being carried out by the Bush administration, it was unlikely that federal law enforcement officials were going to undertake an investigation and prosecution of what was happening. So in effect, that left the North Carolina officials, and the question was whether they were in a position to do anything about the illegal activities in which North Carolina-based aircraft were involved. It turns out that although no one disputes whether North Carolina is subject to international law or subject to treaties that have been ratified by the United States, there is questions about to what extent can North Carolina as a state take action to enforce these obligations. But what is not disputed is that North Carolina has the authority to investigate conduct that might violate international law, and more specifically, has the jurisdiction to investigate conduct that would violate North Carolina law. The State Bureau of Investigation, for example, has statewide jurisdiction to investigate possible crimes being committed in North Carolina. One of the crimes for which there is extraterritorial jurisdiction in North Carolina is conspiracy, when one of the overt acts takes place in North Carolina. So that was something that could have been investigated on the local level, could have been investigated at the state level, and both the Attorney General and the Governor, who has authority over the Governor has authority over the State Bureau of Investigation, could have requested their assistance in investigating what was happening. We've met with the staff of the Attorney General, and we'll meet with the staff of the Governor to talk about our findings, to talk about our position on these issues. I don't think that there is there's a contrary answer to what we concluded. As you know, with lawyers, either they're brought in to advise you how to comply with the law or how to avoid the law. And so we just wanted to make sure that we put on the table, the authority they have to comply with the law.
Professor Kirk, you referenced this a little bit in the response to the first question, but reflecting on the human rights work that you've done in other contexts, including in countries also addressing legacies of torture and other human rights abuses, including Colombia, Peru, Turkey, and Northern Ireland, can you compare some of the accountability efforts that you were involved in there to the work of the NCCIT?
Sure. I think, it's certainly a mixed bag, but I think that it's really important to see this quest for accountability is not simply located in the United States or not simply located in Europe, but in fact, in many countries, there has been a growing body of expertise and accomplishment in terms of gaining accountability for past, whether it's crimes committed during conflict or abuses committed during the course of some sort of a governmental program or what have you. And I think it's important to take some of these lessons to heart for a number of reasons. I think the Truth Commission itself is a technique that really comes out of the Southern Cone in the 1980s and 1990s, Chile and Argentina in particular. Argentina with the Never Again report, Chile with a number of different reports on crimes committed in the context of the Dirty War that have then had echoes in actual prosecutions and convictions of perpetrators. I think in Chile, for example, human rights groups estimate that most of the individuals involved, whether they were with the army or the intelligence services or the police, most of the individuals involved in human rights abuses during the 1970s have actually been prosecuted and convicted. So it's not a process necessarily that happens quickly. It is something that can build, and a Truth Commission report or a citizen-led report like this one can be an important part of keeping that issue not only alive, but in front of citizens. And I think one of the things that I know we'll talk about a little bit, but that really is distinctive about this process is the fact that it's citizen-led and citizen-supported. And in that sense, there have been other processes in countries like Northern Ireland, which has not really had a formal truth commission or truth process. Turkey would also be another country where that hasn't happened yet for political reasons. Yet there are, especially in Northern Ireland, there are efforts underway at the local level to provide some sort of accountability and to also educate people about what actually happened in their name. In Northern Ireland, for example, there's been a huge inquiry into the Bloody Sunday killings in 1969 and 1972, and the families have finally got an answer to why their loved ones were basically shot down during a peaceful civil rights march. And that process is still ongoing in Northern Ireland, and I think that the more support that gets from the citizenry, the more chance there is for some sort of a legal accountability. The passage of time doesn't necessarily, I think it certainly makes it harder in some ways, but I would just point, this is something we've talked about before, to North Carolina's experience with the Greensboro Truth and Reconciliation Commission, which looked into the killings of 5 anti-Klan marchers in 1979. That was the first Truth Commission in the United States, and it was entirely citizen-led and citizen-supported. And while that didn't result in any legal convictions, it did play an important role in educating people not only about what had happened and the police role in the deaths of those protesters, but also really shone a very bright light onto continuing structures of white supremacy and racism in the state of North Carolina. Another report that was done, this one formally organized by the state, is the report into the Wilmington Massacre of 1898. And only recently have we seen that report, and I highly recommend that to people. It's online. You can read it. It's one of the best pieces of investigation I've ever seen, literally a minute-by-minute accounting for how white supremacists planned, organized, and carried out essentially the eradication of an African-American community, a majority African-American community in that time in the largest city in North Carolina. Carried out the eradication of a center of African-American electoral power, economic power. And it's important that we take the lessons from some of these commissions, take the lessons from kind of long-standing and persistent activism on this and say, you know what, even if the federal government is not going to do something right now, and even if the state is not going to do something right now, what we're betting on is that right now is going to become when it actually happens, when there's actual accountability and reports in terms of legal and legal accountability in terms of prosecutions, but also in the passage of laws that make sure, the real goal of this is to make sure it doesn't happen again, that we don't recur to a regime of torture. And as you all know, in this current administration, that's a real and present threat, that we're going to go back there very quickly. So we're hoping that this kind of report and this kind of citizen action is part of the systemic reform that we need to make sure it doesn't happen again.
Catherine, well, the work to uncover and seek accountability for North Carolina's role in the CIA's program has been long-standing. The last year has been marked by several culminating events, including the release of the report launch, et cetera. Can you, looking back over the course of the last year, can you reflect on what some of these efforts mean for accountability?
Yeah, thanks. And many of them, I think, are echoed in what Robin said, which shows as well the kind of from the local to the international. But yeah, unfortunately, it's not an area we're going to see quick change. But I think, we were just talking about outside the importance of having an actual record of this that we can give. Christina has been working on these issues and pushing state lawmakers for the last 13 years. And just to see suddenly, after getting no responses, finally, some people actually emailing us back, which is down to the fact we have a permanent record of this. The fact that we had a really high caliber of commissioners that undertook this, and the fact, as Robin said, that people can see, this is clear and present danger that it might return. We have a president who's openly called for a return to the use of torture. We have a CIA director who is involved in this program. We have international efforts that are coming to grips with their role in this program. And so having this, I think, has really been important for the work in North Carolina. And we've all talked about the importance of citizens. The government at all levels has just not wanted to act, but it's been citizens that have stood up and done something on this, which I think is a model to other struggles on this and other issues across the US. And I think it was also eye-opening to look at the similarities between the victims that we found out of the US RDI program and victims of international human rights atrocities. When you talk to them about what they'd like to see happen, it's really the same. It's apology and it's an acknowledgement, and that goes across the board from all types of survivors. So that's sort of the focus that we have now as a commission is on honouring some of that with the recommendations.
And Christina, as Catherine just referenced, you have a long, more than 13-year history of engaging in this effort really at the grassroots level and mobilizing fellow citizens. Can you share with us some broader lessons about activism that you've learned over this period?
Sure. One lesson I want to share is always pass a petition. Is that all right if I circulate a petition? So this is a petition that you may want to consider signing, and it's to Governor Cooper and Attorney General Stein. And this is part of the effort now to use the report and the findings of the report, the certainty that the report conveys about North Carolina's role in torture, to bring citizen pressure to bear on the governor and the attorney general to distance North Carolina from this policy and to repudiate our past involvement and to apologize and acknowledge the victims, as Catherine was saying. I think the lessons from this process that I would point to have to do with the importance of connecting the local to the global, first and foremost. That North Carolina has this opportunity to weigh in on an issue that's involved our nation in an international scandal, really. The United States breaking up the post-World War II consensus against torture that was fragile anyway, but we had the Convention Against Torture signed under Ronald Reagan. And the United States pushed for other nations to repudiate torture, and now the United States is itself a practitioner of torture, and unapologetically, the United States doesn't apologize internationally for that. And I think North Carolina having sort of that local hook to hang citizen rejection of torture on has been really crucial for us to continue with this issue year after year, knowing that we are the only ones really who are going to take responsibility for trying to end our state's crucial involvement. You know, Aero Contractors still has 130 employees there at the Johnston County Airport. They could be flying rendition flights tomorrow. They have the aircraft, they have the secrecy. Their corner of the airport is heavily fortified using state tax dollars from the Department of Transportation so that protesters can't approach their compound. There's no reason that they couldn't continue these types of human rights abusing activities or other ones that we would have no idea about. So that the urgency of citizen involvement, because it's in our backyard, so to speak, I think has kept this going. And then I think sort of the one other point that I would call out is the importance of human stories, of telling human stories. And if you take a look at Chapter 4, there are the actual accounts of some of the individuals, 48 men and 1 woman, who were rendered by Aero Contractors. And so that's a person-to-person connection that people in North Carolina can make with human beings. And I think the acceptance that many Americans have professed for their government torturing has been based on a systematic dehumanization of the victims of torture. These are people in other countries, they're Muslims. The equation of Muslim with terrorist has been made in numerous popular media and by political officials, politicians, and so Americans have been able to dehumanize and sort of other this population of people who were then tortured, and the acceptance, I think, is predicated on that. So it's been extremely important to learn about the cases of people like Binyam Mohammed, like Khalid al-Masri, and to make those stories, human stories for people, to talk about the children and the families of people who were disappeared so that their families had no idea where they were for years on end. And that, I think, is also has been a really critical component of what we've done.
And the final bonus question for you, Christina, which you've woven in a little bit, but in terms of next steps that you plan to engage in terms of pushing for implementation from the perspective of citizens.
Yeah, I mean, I'll just be brief because I want to hear your questions too, as we all do. One of the key things that we're doing now is reaching out to communities around the state and asking them to participate in contacting Governor Cooper and Attorney General Stein and voicing their concern about their refusal, the officials' refusal to do something about North Carolina's involvement in torture, and calling on them to make public statements, to start that investigation that Jim was talking about. So we also are working closely with the North Carolina Council of Churches, and they have a part-time organizer who is leading outreach to pastors in Johnston County. There's an interfaith coalition, Christian, Jewish, Muslim, in Asheville that's planning an interfaith public convocation in early 2019 to bring together clergy and lay people and people who are not part of any organized religion to talk about how to better put pressure on state officials to do something about North Carolina's involvement in torture. There are congregational meetings happening in Chapel Hill and in Durham. And on the sort of civic level, citizens are reaching out around Human Rights Day in December to ask governments in Durham, in Orange County, in Chapel Hill, Carrboro, and other local governments to make declarations of interest and support for the Commission's work. So basically saying, taking notice of what the Commission has done and calling on state officials to follow the recommendations. Any type of organization, student, community, can make a statement of support for the Commission's work. I would encourage you all to think about what avenues you might have for making that happen. And we're also happy to send speakers to any kind of group that you might be a part of to acquaint people with the issue and talk about how they can make a difference, how they can make their voice heard.
Thank you. So we have just a few minutes to open it up for any questions or comments from the audience.
I had a quick question just on the legal front. Just as I understand the law of kidnapping in North Carolina, this clearly seems to qualify as kidnapping. Any answer from any of the officials as to why this isn't kidnapping as defined in the North Carolina General Statutes?
Well, we think that it could be prosecuted as kidnapping. Again, our view is that what's most important is to investigate the conduct. There's no question that the government has the authority to do that. They have the discretion whether or not to prosecute. So, pressuring them to prosecute, it seems to me, is the wrong emphasis. The emphasis ought to be on the investigation.
Well, thank you all so much for joining us, and thank you for
We're heading to Washington Wednesday? Yeah, so we're doing the event. Let's go get them.